Hello everyone, welcome to Apurva's Legal Bites. I hope all are doing well. And today, before commencing our topic, let me give you a small introduction. Generally, when a dispute arises between two parties, first they try to mutually settle the dispute between themselves outside the court in order to save their time, money, and to avoid the court expenses. But all cases do not result in peaceful mutual settlement. At some point of time, the parties should seek the assistance of the court. What I mean to say is, the matters which are less serious in nature may be compromised between the parties without going to the court. But the matters which are very grave and serious in nature cannot be compromised, means there is no question of settlement between the parties. So there, the intervention of the court is compulsory. So here, the settlement depends on the nature of the case, whether it is compoundable or non-compoundable. So today's topic is on compoundable offences and non-compoundable offences. So under CrPC, section 320 talks about compoundable offences. So before that, first understand compoundable means compromise, settlement. Non-compoundable means opposite of it. That is no settlement, no compromise. Okay. Now coming to the definitions. Compoundable offences are those offences which are relatively less serious in nature and in which a compromise can be made between the parties, that is a complainant and the accused. Whereas non-compoundable offences are those offences where a compromise cannot be made, being very grave in nature and may affect the society at large. Now, compounding of an offence doesn't mean the offence has not been committed. Rather, it means the offence was committed, but the victim, that is the injured party, is willing either to forgive the accused person or to accept the compensation for what he has suffered, provided that the compromise is bona fide and the compensation is the one which the complainant is entitled to. Now, we'll see what the section 320 of CrPC talks about. It has totally 9 subsections. We'll see one after the other, starting with subsection 1. There are few offences which may be compounded without permission of the court, but there are few offences which may be compounded after taking the permission of the court, before which any prosecution of such offence is pending. Okay, the abetment of an offence or attempt to commit an offence, or where the accused is liable under section 34 or 149 of IPC, the offence may be compounded in a like manner. Now, if a person who is a minor, idiot and lunatic cannot compound the offence, instead a person competent to contract may compound the offence on their behalf after taking the permission of the court. And if a person is dead, he cannot compound the offence. Instead of him, his legal representative may compound the offence on his behalf with the consent of the court. And when the accused has been committed for trial, or when he has been convicted and the appeal is pending, the offence is not allowed to be compounded unless with the permission of the court for which the offence is committed or before which the appeal is to be heard. Now, the High Court and the Court of Session, which are exercising their revisional powers under section 401 of CrPC, these two courts may allow any person to compound any offence, provided that such person should be competent to compound the offence and that offence must be compoundable in nature. Okay. Now, no offence is compoundable if the accused person is, by reason of his previous conviction, liable to any enhanced punishment or any different kind of punishment. Subsection 8. It is very important. It says that when the offence is compounded, it has the effect of acquittal of the accused person. And subsection 9 is also very important. It says that no offence is compoundable except as provided by this section. It means that no offence is compounded except under this section 320 of CrPC. There is no other section or no other law where an offence can be compounded. This is the only section dealing with compounding of offences. Okay. Now we'll see what are the differences between the compoundable offences and non-compoundable offences. First, compoundable offences were dealt under section 320 of CrPC, whereas non-compoundable offences, there is no such section for them. Okay. And most of the compoundable offences are non-cognizable. They are less serious in nature. Whereas the non-compoundable offences are cognizable in nature. They are more serious and also affect public at large. And in compoundable offences, the charges framed against the accused person can be withdrawn, whereas in non-compoundable offences, the charges framed against the accused person cannot be withdrawn. And generally, the compoundable offences are filed by a private person, whereas non-compoundable offences are filed by the state. Okay, and in compoundable offences, the offences may be compounded with or without permission of the court, whereas in non-compoundable offences, there is no such option. It can only be squashed. And the most important point is the offences that may be lawfully compounded are mentioned under section 320 of CrPC, whereas the offences other than those mentioned under section 320 are non-compoundable, means they cannot be compounded. Okay, so this is the end of the topic. If you like, please like, share and also subscribe to my channel Apurva's Legal Bites.